Hi, it's Anne-Marie from Charmed Life Therapy, back with another update. It would seem that Kevin Fritz has got sick of me talking about Charles Babcock and has decided to wake up the Vanzan issue, specifically for me, of course, and for you little band of people that watch and support me. So thank you for being here, and we'll go through this latest intrigue about Van Zandt and about the fact that Ryan Reynolds may have claimed responsibility for it a little while ago, but it would seem that he certainly doesn't want to show up and talk about it. So let's break that down because it should be a little bit of fun. I haven't had a chance to look at it beforehand, so I will be seeing it at the same time as you. You may have seen it with somebody else already, but as I say, some of you seem to like just listening to my little voice as we discuss these things. So let's start sharing. Let's see if I can find the right one. I know there's been other things as well. So Blake is after more signal messages or more compelling of signal messages because she still says Steve Sarowitz is not giving me anything. She still seems to think they're picking and choosing as regards the dates that they're giving her and things like that. But I think it's going to go too long if I try to break that one down as well. So later on, I might have a look at it and see if it's worth bringing to you. But in the meantime, we'll just look at the Van Zan of it all. And there are some things under seal, one or two little bits that I couldn't get access to. That'll be to do with Van Zan documents, I imagine. So we'll go this one first, both about the same thing. Let me just blow it up a little bit. So it's Kevin Fritz. So this has come up in Jones versus Abel. So, dear Judge Liman, in connection with the deposition set for September 30th, defendants Jennifer Abel, Melissa Nathan, blah, 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 moved pursuant to Rules 1C and 4C of Your Honour's individual practices and Rule 45 of the Federal Rules of Civil Procedure for an order compelling non-party Vanzan Inc. to designate a witness prepared to testify about the full period of its relationship with plaintiffs Stephanie Jones and Jones Works, collectively the Jones parties. As set forth herein, Vanzan is attempting to curtail its testimony to omit information the court has already declared is relevant. Rule 26 provides that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defence and proportional to the needs of the case, considering, among other things, the parties' relative access to relevant information, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Rule 26 further provides that information within this scope of discovery need not be admissible in evidence to be discoverable. The party seeking discovery bears the initial burden of proving the discovery is relevant. So there's some case law, Loeb versus Loeb, cited there. Once that party has shown relevance, it is up to the responding party to justify curtailing discovery. So Vanzan has to, if they don't want to be upfront and personal, they have to justify why they are curtailing discovery, basically. Ms. Abel's counterclaims allege that in August 2024, just prior to her scheduled departure from Jones Works, the Jones parties seized her cellular phone, accessed the contents, and downloaded them. The counterclaims further allege that Stephanie Jones disclosed at least some of Ms. Abel's private communications to the Lively parties no later than August 21st, 2024, continued to access Ms. Abel's private text messages thereafter, and at some point transmitted Ms. Abel's stolen communications to Ms. Lively, her husband Ryan Reynolds, and Leslie Sloan, Ms. Lively's publicist, to harm Ms. Abel. Ms. Abel also alleges that Ms. Lively conspired with the Jones parties to obtain Ms. Abel's stolen data under the guise of legal process. On September 27, 24, Ms. Lively used her company Vanzan to file a lawsuit in the New York State Supreme Court against Doe defendants, the Vanzan lawsuit. The complaint in the Vanzan lawsuit alleges that the Doe defendants, the identities of whom are unknown to Vanzan, breached unspecified obligations via unspecified oral promises and/or unspecified written agreements. Days after the Vanzan lawsuit was commenced, Vanzan issued a subpoena therein to the Jones parties demanding the production of documents pertaining to the film Ends With Us, Ms. Lively, Mr. Reynolds, and sexual H and retaliation in connection with the production of the film, none of which are even remotely referred to in the complaint filed in the Vanzan lawsuit. The Jones parties then handed over Ms. Abel's communications to Vanzan. Subsequently, the Vanzan lawsuit was discontinued in December 2024. The same month, Ms. Lively included those communications in her pleadings. In late June 2025, Ms. Abel filed a motion to compel Vanzan to produce certain documents in response to a subpoena. In a memorandum and order dated July 7th this year, the court properly determined that communications between Vanzan and or its counsel and the Jones parties and or their counsel concerning the Vanzan lawsuit are relevant. Specifically, the court noted that the statutes under which Ms. Abel brings her claims prohibit both obtaining and disclosing protected information. The court correctly stated communications between Vanzan and or its counsel and Jones Works and or their counsel concerning the Vanzan lawsuit are likely to bear on or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Vanzan or Lively. Bear with me a moment. The Wayfarer Party's deposition subpoena, as amended, the subpoena, commands Vanzan to produce a witness who can testify about enumerated topics, including the ownership and management of Vanzan, Vanzan's communications with the Jones parties, the subpoena issued in the Vanzan lawsuit, communications with Ms. Lively related to that subpoena, and Vanzan's search for relevant documents. To the extent that topics number 4 and 5 could be construed as overly broad, the Wayfarer parties have agreed to A, narrow topic number 4 to Jennifer Abel's counterclaims in this action and the defences thereto, and B, narrow topic number 5 to Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communication cited in her pleadings in connection with a lawful subpoena. So it's going to be a little bit interesting, is this, as to figure out why they thought it was a good move to claim Ryan as the CEO of Vanzan, isn't it, in the way that they did? Is it so that they can argue that actually he doesn't know about why this lawsuit was put into place, so that he can't be deposed in a way because he can turn around and say he has no knowledge of why? Could that be an argument as to why it is? As I was reading that, it came up into my mind, just an idea. It could be right or wrong. Did he actually know about the Vanzan lawsuit before she did this? Because we've got to that is kind of the big mystery, I guess, to us all, isn't it? That bothers us all so much is between Blake and Ryan, were they working in concert on this right from the beginning? Or did Blake pull Ryan into something that he didn't know about, or she alluded to things which made him respond or react in a negative way because he's touchy about so many things, it would seem. But did he know she'd done this with her fake company? Because whatever you want to say about Ryan, you have to credit him with some intelligence. Because this all along has seemed a bit dodgy, because you think, why wouldn't they think that this would come up, that this wouldn't be exposed? You know, those text messages and how important they are in terms to whether she, in terms of proof or a reason for actually bringing a complaint or whatever. It's going to be front and center in the defense's mind as to where did these come from? How did they get them? How did we not know in advance that these had been requested, because like if there'd have been a subpoena, we should have got word there was a subpoena and all of this. So you know the defense, so anybody in the right mind would know that the defense is going to be on it. And that to me kind of sends back the message in my brain. Because I just have this feeling that Blake and her attorneys initially were dumb enough to think that this CRD was just going to stop everything. Like that CRD would happen. He couldn't do anything about it. She would get to have her PR turned on its head again, back in a positive direction. Nobody would challenge it. Nobody would say anything about it. And you can understand Blake being dumb enough to fall for that. And I don't, and when I'm saying that, I don't mean that I'm calling her dumb necessarily. It's just mean that uninformed in the law. But the lawyers don't have that excuse, do they? Her lawyers. So, and Ryan to me, love him, hate him, whatever you feel about him, he ain't that, I don't feel he's that dumb, is he? Is he? You know what I mean? So anyway, nonetheless, Vanzan is refusing to provide a witness who can testify at a deposition about such communications and the related topics. Well, who is there in Vanzan? I guess we don't know yet, do we? We don't know. Is it just Blake and Ryan? Is there more people than that? There might be some more information further down the line while we read this. Anyway, according to its written objects to the subpoena, the objections, Vanzan will only provide information for each of the topics, starting from, on, or about the filing date of the Vanzan lawsuit, which is September 27, 2024. Subject to that unreasonable limitation, Vanzan stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information to respond to these topics. I think they're just going to say, we don't know, we didn't work here at that time, we weren't responsible for that, we can't find any paperwork to do with it. Stated differently, Vanzan only agrees to produce a witness to testify about what happened after the Vanzan lawsuit was commenced, but not before it was filed. Even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan is highly relevant to Ms. Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan is refusing to designate a witness prepared to testify about the foregoing. I think they've got the date wrong there, haven't they? They're saying September 27, 2025. So Vanzan is flat out refusing to designate a witness prepared to testify about the foregoing. That's because Vanzan and its limited number of people behind it do not want to say what they did. So none of the people involved in Vanzan, however many there is, are prepared to testify because they just blatantly just don't want to say, basically, isn't it? Vanzan argues that the information sought is obtainable from other sources. They all try to do this from time to time, don't they? However, as the court stated in its memorandum and order, there is no per se rule that party sources must be exhausted before documents are subpoenaed from third parties. Everybody's used this argument. Putting aside that no other witness has testified about most of the topics, even if such cumulative testimony existed, the Wayfarer parties are entitled to test what witnesses to the same events have to say and whether they contradict or corroborate each other. There is no undue burden imposed upon Vanzan. The corporation has known for months, and certainly since June 2025, when Ms. Abel moved to compel its compliance with a document subpoena, that it was in possession of information material and relevant to the claims and defences herein. Furthermore, given the allegations in the counterclaims, the relevant period is not expansive. Although the subpoena defines the relevant time period as January 1st, 2022 to the present, the Wayfarer parties agree to limit the relevant time period to July 1st, 2024 through December 31st, 2024, which nobody can really argue that's asking a lot, is it really? It's not asking a lot at all, really. The subpoena was initially issued on September 9th, 2025, and noticed the deposition for September 29th, 2025, which was later adjourned to September 30th, a period of 20 days for compliance, which is far more than the 14 days that courts in this circuit have found to be presumptively reasonable. Therefore, the Wayfarer parties respectfully request that the court issue an order compelling Vanzan to designate a witness prepared to testify at deposition about the full extent of the relationship between Vanzan and the Jones parties, including the period before the Vanzan lawsuit was filed. In the event the court grants this application after Vanzan's deposition commences on September 30th, 2025, the Wayfarer parties respectfully request that the court direct Vanzan to designate an appropriate witness to appear for a deposition consistent with the court's ruling concerning the topics during the first 2 weeks of October 2025. Now, in my mind, Vanzan haven't got a leg to stand on here because nobody's asking too much of them, in effect, is it really? They can't. How are they going to maintain that anything they have is irrelevant when basically the whole lawsuit rests on it, doesn't it? Rests on those text messages and whether they were legally obtained in order to sustain that original complaint of hers, and the New York Times article and the rest of it. So let's go to, I think this is where they back up the argument, isn't it? This says Kevin Fritz's declaration in support of the motion to compel. So I, Kevin Fritz, pursuant to 28 USC, blah, blah, hereby declare as follows. I am a partner of Meister, Seelig and Fine, attorneys for Jennifer Abel, Melissa Nathan, the rest of them, in the above captioned matter. I submit this declaration in support of the Wayfarer party's motion to compel non-party Vanzan to designate a witness prepared to testify at deposition about enumerated topics set forth in a subpoena served by the Wayfarer parties as amended the subpoena. I think that is the whole problem, isn't it? I mean, who the hell is there to designate, to testify, really? I mean, who in the right mind is going to want to testify, be it Blake, be it Ryan, be it whoever else is named on that Vanzan, because they literally know, don't they, that they've got, it's like, because they would be questioned about how come you don't know what contract was involved, how come you don't, how did you know why wasn't Jennifer Abel named, why wasn't Justin Baldoni named, or why wasn't all of the names, Stephanie Jones's name. You know what I mean? It makes no sense, does it? Well, why did you go to these people if you claim they're no defendants? It's like, how is anybody going to testify to that? How is that going to work? It's no surprise they don't want to testify about the things that happened before the actual subpoena went into play. So the deposition of Vanzan's representative, who has not yet been identified by Vanzan, is scheduled for September 30th at 10 a.m. in New York, according to a biennial statement filed with the New York State Department of State Division of Corporations on June 30th this year. The chief executive officer of Vanzan is Ryan Reynolds. A true copy of the biennial statement is attached as Exhibit A. I feel like if he showed Mr. Reynolds is the husband of Blake Lyman, just in case Judge Lyman doesn't know by now. I could see a scenario where he would show up to a deposition and just say, I have no knowledge, I have no knowledge, I have no knowledge other than what my attorney told me. You know, that Blake relied on so much, didn't she? I don't know anything other than what my attorney told me, hence I cannot comment on that. I can see a scenario where he would show up and do that. True excerpts from the transcript of the deposition of Blake Lively conducted on July 31st are attached as Exhibit B. A true copy of the complaint filed by Vanzan and against those 1 to 10 in the Supreme Court, New York County on September 27, 24, the Vanzan lawsuit is attached as Exhibit C. a true copy of a subpoena issued by Vanzan to Stephanie Jones and Jones Works. And don't forget, they really didn't want to even give that over, didn't they? Do you remember there was a whole kerfuffle about you already have it, we don't have to give you it, and all of that. They fought it all the way, haven't they? So a true copy of a subpoena issued by Vanzan to Stephanie Jones and Jones Works, collectively the Jones parties in the Vanzan lawsuit, is attached as Exhibit D. A true copy of a notice of discontinuance filed by Vanzan in the Vanzan lawsuit on December 19th is attached as Exhibit E. According to the docket from the Vanzan lawsuit, a true copy of which is attached as Exhibit F. Vanzan did not file a request for judicial intervention and no judge was assigned to the case. On September 9th, the Wayfarer parties issued the subpoena to Vanzan, which commanded A representative of Vanzan to appear for a deposition on September 29th, and B, the production of documents. The true copy of the subpoena dated September 9th is attached as Exhibit G. On September 11th, 2025, Vanzan's counsel accepted service of the subpoena. On September 18th, the Wayfarer Party's counsel and Vanzan's counsel agreed that the deposition would be held on September 30th. Accordingly, on September 18th, the Wayfarer Parties issued an amended subpoena containing the September 30th date for the deposition. The true copy of the subpoena dated September 18th is attached as Exhibit H. So there, just in the footnote, it says the exhibit also includes the errata sheet applicable to the submitted portions of the transcript, as well as Ms. Lively's signature. The Wayfarer parties are not seeking to compel the production of documents. Right, let me just scroll up a little bit. So 13, the topics for which the subpoena seeks deposition testimony are as follows. Lively's direct or indirect ownership interest in you, meaning Vanzan. Ownership interests in you, your managerial structure, the parties' claims, allegations, defences and counterclaims in this action, topic number 4. The parties' claims, allegations, defences and counterclaims in the action Lively versus Wayfarer Studios et al., topic number 5. Your relationship and communications with Jones, your relationship and communications with Jones Works, the issuance of and communications relating to the subpoena, your claims and allegations in Vanzan Inc. versus Does 1 to 10 inclusive, your communications with Lively relating to the subpoena, your document collection, document search and document production in this action. So 14 then, it goes to, on September 22nd, 2025, I met and conferred telephonically with Vanzan's counsel about its objections to the subpoena, including the topics on which the Wayfarer parties seek deposition testimony. Vanzan's counsel claimed that the testimony sought could be obtained from a party, so it would be Jones Works, wanted it would have been trying to bounce it back to her. When I asked Vanzan's counsel to specify which party, Vanzan's attorney, John Fetterolf, Esquire, stated that his understanding was that Blake Lively testified about the topics. In response, I asked Vanzan's counsel if they possess a copy of Ms. Lively's deposition transcript, which has been designated confidential under the protective order. Vanzan's other attorney on the call, Margarita O'Donnell, Esquire, answered, "We're not answering that," or similar words to that effect. Because I wonder if they can prove that they have it, if that then kind of questions whether that can remain confidential. I don't know, not legally minded, but it does raise that question, I would imagine. Ms. Lively did not testify about Vanzan, except for one sentence, Exhibit B. On the evening of September 24, 2025, Vanzan served its objections and responses to the subpoena, the objections. A true copy of the objections is attached as Exhibit 1. In the objections, Vanzan objected to all the topics, alleging that the testimony sought is irrelevant to the claims, defences, facts or circumstances related to this action. Furthermore, Vanzan stated that it will only provide information for each of the topics starting from on or about the filing date of the Doe lawsuit i.e. the Vanzan lawsuit filed on September 27, 2024. Subject to that unreasonable limitation, Vanzan stated that it would designate a Rule 30b-6 witness reasonably prepared to testify about non-privileged information in response to these topics. And that's what I think. I think when they say reasonably prepared, it's going to be somebody, whoever it may be. It certainly won't be Blake, but somebody's going to have to take it on the chin, who is going to have to sit there and say, I know nothing, I have no knowledge, I have no paperwork, I don't know anything about it. This is why it was dozed, because we simply didn't know. They're going to have to come up with some story. Somebody, some shill, someone, some patsy is going to have to sit there and stick this. I don't see how they can get away with not providing a witness. When they've agreed a deposition date, somebody has to do it, surely. Isn't that how it works? So stated differently, even though the communications between Vanzan and the Jones parties or their respective representatives concerning the contents of Jennifer Abel's electronic data seized by the Jones parties and subsequently delivered to Blake Lively through Vanzan is highly relevant to Ms. Abel's counterclaims against the Jones parties, and even though such communications surely occurred before the Vanzan lawsuit was filed on September 27th, Vanzan has refused to designate a witness prepared to testify about the foregoing. Upon receiving the objections, the Wayfarer parties agreed via email to A, narrow topic 4 to Jennifer Abel's counterclaims in this action and the defences thereto, and B, narrow topic 5 to Blake Lively's allegation in paragraph 10 of her second amended complaint that she obtained the communication cited in her pleadings in connection with a lawful subpoena. A true copy of an email chain between counsel is attached as Exhibit J. Furthermore, and with respect to Vanzan's relevancy-based objection, the Wayfarer parties reminded Vanzan that in its order dated July 7, 2025, the court already determined that discovery from Vanzan was relevant to Jennifer Abel's counterclaims against the Jones parties. Given that the Vanzan deposition is scheduled for September 30th, nearly a few days from now, the Wayfarer parties asked Vanzan to withdraw its objections to the topics by noon Eastern Standard Time on September 25th. Vanzan has failed to do so. I declare under penalty of perjury that the foregoing is true and correct. So you drop me a comment and tell me what you think about that. I might just have a look at the Blake stuff later, the Blake signal stuff that she's complaining about. So this one, then this video doesn't go too long. But yeah, it's what I would expect now, because we would certainly see it if it was on Blake's side of things, is that the judge would have to promptly respond to this because there's a time element involved. And certainly it would seem that whenever Blake's side has had a time element or something's gone overdue or whatever it is, the judge is on it like this, isn't it? So I would expect that what we on the 26th today, that he has to get on this sharpish. Because it's kind of crazy, isn't it? They've agreed to sit for a deposition, but nobody's agreed to testify. No, it's like, well, what's going to happen? Is a bunch of lawyers just going to show up and what? what is going to happen? So what is it you think? What is your theory? I would be interested to know. Like I said, my thing is, why did Ryan agree to take on board being CEO of Vanzan? There was a reason for that, wasn't it? Presumably it was to protect her from her having to sit for any Vanzan related deposition. So does he think he can brass face it? You know, sit there like a brass monkey or whatever whatever a correct thing is, you know, go sit for this deposition in full on Deadpool mode and just be an asshole. Is that his plan, do you think? Does he want to do that? What's going to happen, do you reckon? Maybe he'll send you Jackman in a blue and pink cardigan, or Brendan Sklenar or somebody like that. Well, What's your theory? Who who is he going to nudge to show up on his behalf? And what is your theory as to who else may or may not be behind Vanzan? I would be interested to hear. But please do hit that like and subscribe and share if you're enjoying this at all. Thank you for watching to the end, and please do always read my description boxes too, because I drop all of my links in there with my free stuff and free hypnosis recording, booking a free call with me if you want to talk about hypnotherapy, which is my real job. And I am very good at it, better at doing my real job than I am at doing these videos. But there you go. Hope you enjoyed that, and I will see you later.